Good afternoon, ladies and gentlemen, and welcome to this meeting of the Standing Committee on Justice and Human Rights. It's a great pleasure to welcome our Minister of Justice and Attorney General for Canada, Jody Wilson-Raybould, together with so many different people from the departments that I'm not sure I can introduce everybody. But I wanted to say how much I want to thank all of those people from all of the different departments and agencies that are here with us to provide backup and support to the Minister and to the committee. Thank you all for your work and your diligence. C'est vraiment apprécié.
So appreciated. All your work on a daily basis. We don't get enough chances to thank you, to thank all of you working for the department and all its sections. For the committee, I thank you for your work, for your diligent work.
Move straight to the testimony of the Minister, and then we'll move to questions. So, Minister, the floor is yours. Thank you for being here.
Well, thank you, Mr. Chair, and certainly always appreciate being in front of this committee, and look forward to answering questions after I make some brief remarks. I, of course, want to acknowledge the territory of the Algonquin people. And just for your benefit, Mr. Chair, the benefit of the committee, I'm joined by William Penny, Deputy Minister of Justice and Deputy Attorney General, Nathalie Drouin, Associate Deputy Minister, Donald Paragoff, Senior Assistant Deputy Minister, and Joanne Bernard, Assistant Deputy Minister and Chief Financial Officer. Today I'd like to talk to you about how the Department of Justice Canada intends to use its funds granted through 2017-2018 main estimates to ensure a fair, relevant and accessible Canadian justice system and a federal government that is supported by high-quality legal services. Mr. Chair, as you are aware, the Department of Justice has a total budgetary authority of $656.1 million through 2017-2018 main estimates. This represents a decrease of $22.7 million from main estimates of the previous fiscal year. However, earlier this morning, our government tabled the 2017-18 Supplementary Estimates A. This includes $45.9 million announced in Budget 2017 for the Department of Justice, which offsets the previously mentioned decrease, resulting in proposed authorities in the amount of $702.1 million to date. In addition to the budgetary authority, the Department is also granted a vote-netted revenue authority of $296.2 million to collect fees to offset a portion of the cost of legal services offered to other government departments. Some of the $385 million of this year's authority will be used to help support the stewardship of the Canadian legal framework by directing funding to the provinces and territories. In 2018, or the 2017-2018 main estimates also indicate departmental operational expenditures of $234.3 million. Mr. Chair, as the Minister of Justice and the Attorney General of Canada, I take my responsibilities and accountabilities very seriously. I would now like to speak more broadly about how the budget authority granted to the Department of Justice through the main estimates will help support my role as the steward of the Canadian justice system and ambassador of the Canadian Charter of Rights and Freedoms, which celebrates its 35th anniversary this year. First, my review of the criminal justice system is ongoing. It is intended to ensure that our criminal laws protect Canadians, hold offenders to account, meet the highest standards of equity and fairness, respect for the Charter, and show compassion to victims. This, in turn, will help promote a justice system that protects Canadians, their communities, and their rights. In March, I introduced legislation that would remove or amend provisions of the Criminal Code that have been declared unconstitutional by the Supreme Court of Canada and appellate courts and have no force in law. Removing these and other invalid provisions will make the Criminal Code more clear and accessible and help Canadians, including those involved in the criminal justice system, to better understand the current state of the law. This is the start of our modernization of the criminal justice system to ensure that it shows the greatest possible respect for the Charter and it promotes access to justice. Earlier this year, I also worked with my colleague, the Honourable Melanie Joly, Minister of Canadian Heritage, to reinstate and expand the Court Challenges program. This program will ensure that the government remains accountable for protecting official languages and upholding human rights, and promoting access to justice for Canadians who need it most. And more recently, I have been discussing the Supreme Court's decision in Jordan with my provincial and territorial counterparts. That decision proposed new ceilings and an interim framework for assessing when an accused right to be tried within a reasonable time under the Charter has been infringed. At our most recent federal, provincial, and territorial meeting, we identified mandatory minimum penalties, bail, administration of justice offences, preliminary inquiries, and reclassification of offences as priorities for legislative reform. Along with this most recent ministerial meeting, there have been continuing and ongoing discussions on access to justice among provincial and territorial ministers of justice and public safety, as well as other officials. We are all committed to ensuring that our criminal justice system is efficient and effective and that Canadians can have the utmost confidence in it. Moreover, our government will continue to address vacancies in our superior courts. Our process for judicial appointments is emphasizing transparency, merit, and diversity, as well as the highest standards of excellence and integrity. Additionally, Budget 2017 proposes additional funding of $55 million over 5 years, beginning in 2017-2018, and $5.5 million per year thereafter for 28 new federally appointed judges. Mr. Chair, I'm also committed to doing my part to renew the Government of Canada's nation-to-nation relationship with Indigenous peoples based on the recognition of rights, respect, cooperation, and partnership. As a country, we know we have much work ahead of us in ensuring that Indigenous peoples can take their rightful place within Confederation. And there is no question that Indigenous peoples and communities are in a tremendous period of transformation and of transition, rebuilding their nations. Our government recognizes that reconciliation requires an all-of-government approach based on recognition of Indigenous peoples and their rights to address the colonial legacy in a substantive and meaningful way that will be transformative. In addition to committing to implementing the United Nations Declaration on the Rights of Indigenous Peoples without qualification, the Prime Minister recently established a working group of ministers to review all federal laws and policies. I'm honoured to have been asked by the Prime Minister to chair this new working group. Our working group's mandate is nothing short of transformative to decolonize federal laws, policies, and operational practices, and to ensure that all aspects of Canada's relationship with Indigenous peoples are rooted in the recognition of rights. Mr. Chair, our government has also included measures in Budget 2017 to support the implementation of the Truth and Reconciliation Commission of Canada's calls to action, including specific measures to address the overrepresentation of Indigenous peoples in the criminal justice and correctional system. Among these measures are the Indigenous Justice Program, formerly the Aboriginal Justice Strategy. Budget 2017 proposes to invest $55.5 million over 5 years, starting in 2017-2018, as well as $11.1 million per year ongoing. This will provide long-term and stable investment in this program to encourage the use of community-based restorative justice approaches as an alternative to the criminal justice system and corrections. Budget 2017 also proposes to provide $65.2 million over 5 years beginning in 2017-2018 and $10.9 million thereafter to help reverse the trend of Indigenous overrepresentation in Canada's criminal justice system and corrections, and to help previously incarcerated Indigenous peoples heal, rehabilitate, and find good jobs. Finally, Mr. Chair, the Government of Canada is unwavering in its commitment to ensuring that victims of sexual assault and gender-based violence are treated with the utmost respect and dignity. This commitment extends to Canada's judges and the judicial system. All Canadians should have confidence in the quality of Canada's judges and the judicial system. To ensure that Canadian judges are sufficiently informed and sensitive to the evolving nature of Canadian society, as announced in Budget 2017, our government increased funding to $2.7 million over 5 years and $500,000 per year thereafter for judicial training and judicial conduct with a gender and cultural lens. In addition, almost $100,000 in new funding from Justice Canada will be provided to the National Judicial Institute to develop training for both federally and provincially appointed judges that will focus on gender-based violence, including sexual assault and domestic violence. Moreover, the Department of Justice Canada will continue funding its programs and services to support survivors of sexual assault and gender-based violence, and working with the Status of Women Canada on the federal strategy on gender-based violence. To date, Justice Canada has approved more than $10 million in funding to 46 projects over 3 years. And our ongoing review of the criminal justice system, as I mentioned earlier, will include a review of criminal code provisions related to sexual assault and consent. To conclude, I certainly would like to thank your committee for the important work that you continue to do. Thank you for the opportunity to provide these opening remarks and overview, and I look forward to answering any questions that the members may have. Thank you, Mr. Chair.
Thank you very much, Minister Wilson-Raybould, for those very cogent remarks. And we will start now with the first round of questioning. I think colleagues will be doing 2 rounds while the minister is here. So we're going to start with Mr. Nicholson.
Thank you very much, Mr. Chairman, and thank you, Minister, and to all those with you here today. Thank you for your appearance here. It's much appreciated. There's so many different aspects of this department, and your involvement certainly as Attorney General. One of the responsibilities you have is, of course, is to either intervene or to get involved with all the lawsuits and the applications before the court that can involve the federal government. I'd like to direct your attention to one in particular. You perhaps, I'm sure you've heard a couple of weeks ago, the Supreme Court announced that it will hear a New Brunswick appeal of a lower court ruling that said citizens have a constitutional right to, in this case, to purchase alcohol in Quebec and take it into New Brunswick. I'm assuming, first of all, that you would support domestic free trade between the provinces, and you would support getting rid of limitations and restrictions on interprovincial trade. Is that I'll give you that question to begin with.
Well, thank you for the question, and certainly I'm incredibly proud of our government in terms of negotiating the Canada Free Trade Agreement, and I know that in terms of the work that the Minister of Innovation is continuing to undertake, is certainly mindful of that lawsuit and will continue to work with his counterparts in terms of the application of that agreement.
I'm sorry, I missed that. You'll work with his counterparts. Who would that be specifically?
The minister is working with his counterparts in the province. In
terms of the legal actions before the Supreme Court of Canada, is it your intention to intervene and get involved with that particular case?
I will continue to work with my colleague, the Minister of Innovation, and take the appropriate action as we determine moving forward.
I think it would be very helpful, and I hope when you're talking with this minister, you'll indicate to him that as important as it is to have a free trade agreement with the United States or NAFTA or with Europe, certainly free trade within Canada somewhere along the line has to also be a priority, and I'm hoping in your discussions with him that you will encourage the minister to get involved with this case as either an intervener status here or a support, because this is a critical one. Will you take that advice?
I will certainly relay those comments to the minister.
Right, thank you very much. Minister, one of the pieces of legislation that you have introduced is, of course, with respect to cannabis. And when you were here just about a year ago, one of the questions I asked you was this. I said, just to be clear, with any changes the government does bring forward on this, which is marijuana, is it still going to be illegal for children to have marijuana? Is that correct, Minister? And your answer to that was correct. I was very polite. I said, thank you very much. You know, but that's just the quote here. But what I'm concerned about, Minister, is the briefings that we have received on this. The Bill C-45 that's before there, it says, it is prohibited for a young person to possess cannabis, one or more classes of cannabis, so the total amount, which is determined in accordance with Schedule 3, is the equivalent of more than 5 grams of cannabis. Then it goes on to say that it's prohibited for a young person to distribute more than 5 grams of cannabis. So can I interpret from that, and I hope that's not the case, is that young people between the ages of 12 and 18 can possess and distribute, or presumably sell cannabis if they limit it to 4 grams?
Well, thanks for the question. There's nothing in Bill C-45 which makes it legal for a young person to possess cannabis. We did, in developing the cannabis bill, have discussions around ensuring that we find some balance, recognizing the ultimate objective of our legislation, of course, is to legalize, strictly regulate, and restrict access, to keep it out of the hands of children and the proceeds out of the hands of criminals. We, in having discussions around penalizing young people for possessing small amounts of marijuana, we sought to recognize and balance the ultimate objective of which we are trying to achieve, along with ensuring that we do not criminalize young people for possession, which would lead to criminal records. But we are working very closely with the provinces and territories to see them move forward with regulation in this regard, and laws around similar to that of alcohol.
What is going to be the status? I mean, the law is very clear that if you're in the schoolyard, I guess, selling more than 5 grams, if you're a teenager or a young person, that's prohibited. If you possess, 5 or more grams. But I'm talking about the individual. Let's just say he or she shows up in school with 3 or 4 grams at school. And what is the status of that?
Well, again, this is, we have, in terms of young people being involved in selling or having other individuals use young people in trafficking, have imposed in this legislation very serious penalties in terms of the maximum penalties. But again, in terms of less than 5, this is something that we will continue to work with the provinces and territories on, to provide options for, as they have around alcohol, to law enforcement officers, to ensure that we don't over-criminalize young people, and it's the balance that we. I
think we're trying to over-criminalize, but you can see there's a gap here in the legislation here that I suppose if you're you're into the business of a young person just selling the stuff, you'd want to be careful not to put more than 5 grams in your pocket if you're going to start selling. But I mean, I'll be very interested to hear what if anything, is going to be the result of this, because it seems to me that the bill, one of the intentions of the bill was to so-called protect children. If you make it not illegal, if you are buying or selling and possessing 4 grams of marijuana, I think that's a problem.
Well, I mean, selling is always illegal with respect to cannabis, but again, we are working very closely with the provinces and territories to come up with a comprehensive regime that improves on the status quo, because the status quo simply isn't working. So,
areas that we'll go. Just one more question, Mr. Chairman. Again, the rationale behind, or in part for this bill, was to better protect children. Wouldn't you admit, Minister, though, that if every household in Canada can now have up to 4 marijuana plants or something, that children will have the greatest access possible to marijuana if you've got the plants in the house? Wouldn't you say that that's a ticket to an invitation to young people to get involved with marijuana?
Well, I will say that we, in developing Bill C-45, had the benefit of working with health and safety experts, had the benefit of a substantive review and recommendations provided by the task force. Having 4 plants was a recommendation that was provided by the task force. But I will say broadly, or on a high level basis, I want to reiterate the purpose of us introducing this legislation. The status quo is not working. It is very easy for a young person to gain access to cannabis right now. What we are seeking to do in legalizing is to strictly regulate and restrict access to cannabis in order to keep it out of the hands of kids and the proceeds out of the hands of
With me, though, if you've got 4 plants in the house, that's greater access than is allowed under the current law?
Again, we're going to work with our counterparts in the provinces and territories to put in place a comprehensive regime that will provide the strict regulation and restrict access.
Thank you very much. We're going to go to Mr. Boissonnault now. Mr. Boissonnault.
Thank you, Mr. Chair. Minister, thank you for being here today. Really appreciate your comments, your approach to your role as Minister. As a member of Indigenous Caucus, I'm particularly interested in all the good work that you're doing to increase access and reduce the over-representation of Indigenous peoples in the criminal justice system. I'm wondering if you could describe for us briefly the Indigenous Court Work Program, why you believe this funding is important, and how it will improve access to justice. And then I have 2 others.
Well, I mean, the Court Workers Program has been around for a long time. Very pleased that we were able to inject $4 million into the court workers in budget last year. The court workers provide Indigenous peoples that are confronted in the criminal justice system with a friendly face, somebody that can assist them in navigating through courtrooms, procedures, articulating in some cases within the courtroom on behalf of the individual, but assisting them in navigating and providing a bit more of a comfortable place for individuals that find themselves in the courts.
Understood. I have to just share a personal anecdote with you, Minister. I chose not to go to law school, and so to be a member of Parliament and sit on the Justice Committee and be able to ask questions of the Justice Minister is like a particular geeky thrill for me today, so I'm happy that you're here.
Happy to.
And I just want to say, I want to ask you a question about LGBTQ rights and what we're doing as a Ministry of Justice to protect and promote the rights of LGBTQ people in Canada.
Well, thank you for the question and geeking out a bit. I think that's pretty fantastic. I mean, as a country, we, and this is in the words of the Prime Minister, we are strong because of our diversity. And as Minister of Justice, I am committed, as is our government, to ensuring that the rights of all Canadians are upheld and propelled. In terms of LGBTQ2 rights, it was my great pleasure to build upon the substantive work that advocates of the trans community have been putting forward for years and years and years to introduce Bill C-16, which seeks to add gender identity and gender expression as a prohibited ground in the Canadian Human Rights Act, as well as make amendments to the criminal code to add gender identity and expression to the identifiable groups and add as an aggravating circumstances in terms of sentencing to ensure that people can be free to be who they are, to express their gender identity and expression in the way that they see fit. I'm also very pleased that the Prime Minister has put a substantive focus on LGBTQ2 people and has appointed a secretariat headed by yourself, Mr. Boissonnault, to assist in this regard and to ensure that their rights are advanced in a substantive and a concrete way.
Well, it's a great honor to serve in this role, and I thank you and the officials for the constructive relationship and the progressive approach that we have to a range of issues, including repealing Section 159 of the Criminal Code. And I know there's more to come, so thank you and to your whole department. Pour un instant, je vais mettre mon ancien chapeau.
And for a moment now, I'll wear my old hat of Parliamentary Secretary. I would like to congratulate you for the work that you have done with the Minister Mélanie Joly, that of appointing justices to the Supreme Court who are able to operate and work in both official languages of Canada. I think this is a great step forward for minority language communities, official language minority communities across the country.
Is studying the full access for the full implementation of the Official Languages Act in the criminal justice system, and that study is underway. But what are some of your, I would say, goals or hopes, or what would you like to see improved in terms of providing access to minority language communities to the justice system?
Well, as an overarching statement, individuals have the right to be heard and to go through the justice system benefiting from both official languages. I was pleased to see $2 million that was provided to court administration services to further assist in making decisions available in both languages. And again, I'm really proud of the process, and you spoke about it, that we put in place, or the Prime Minister put in place, to ensure that appointments to the Supreme Court of Canada are incredibly meritorious, diverse, and ensure that are all functionally bilingual. And we certainly received all of those things with the Prime Minister's appointment of Mr. Justice Malcolm Rowe.
Thank you very much.
Thank you very much, Mr. Boissonnault. Mr. McGregor?
Thank you, Mr. Chair, and thank you, Minister, for appearing before this committee. I wanted to just read out something from the Liberal platform of 2015, where it stated that, and I quote, "Arresting and prosecuting for cannabis offences is expensive for our criminal justice system. It traps too many Canadians in the criminal justice system for minor, non-violent offences." Minister, would you still agree with that statement?
In terms of cannabis?
Like that, the fact that arresting and prosecuting for these offences is expensive for the criminal justice system, that it ties it up. Would you agree with that statement still from the Liberal platform of 2015?
Well, in terms of advancing on the Liberal platform, this is why we have introduced Bill C-45 to legalize, strictly regulate, and restrict access to cannabis in order to keep it out of the hands of kids and the proceeds out of the hands of criminals. We have had much discussion about simply decriminalizing, but simply decriminalizing would not achieve those objectives. That is why we are working extremely hard based on the input of the task force and working with the provinces and territories to ensure we move forward and have a comprehensive regime that in the near future will assist us in achieving those objectives.
And Minister, when I take that as a yes, a long yes. When I've spoken with police forces in local areas like police from Victoria and Saanich on Vancouver Island, and I've asked them about why are they not enforcing marijuana possession offences, charging people for it. They say they have more important things to look at. But when you look at police forces across the country, it's a real patchwork quilt. In other words, the law is not being applied equally, and I don't think it lives up to the standards of a Canadian being a Canadian across this great land of ours. So I'm just wondering, with all the costs, interim costs, and I understand you want to keep it out of the hands of children, but your government has admitted many times that it's easier for a teenager to go and get marijuana now on a street corner than it is alcohol or cigarettes. That's a fact. I'm just wondering why your government feels it's still necessary to keep applying criminal law, which you have admitted is unjust, while we wait for legalization to come through. Surely this would be a good gesture to get rid of criminal records, which I think we can all admit do a lot of harm to a person's life in terms of their job prospects, their ability to travel, and so on. So I'm just wondering why you just couldn't give direction to prosecutors, to police across this country to make sure that instead of a patchwork quilt, we have equal application of the law.
Well, on the latter question, in terms of criminal records, certainly, and the Prime Minister has indicated this is not within my domain, but the Minister of Public Safety is something that ultimately he will be looking at in terms of the criminal records. But in terms of unequal application of the law, I mean, this is the nature of our federation, and we are, and again, I'll underscore, working in a collaborative manner with the provinces and territories. We have taken the time that we deemed necessary to ensure that we got a substantive amount of input from public and health experts, justice, law enforcement, plus the task force on cannabis to help contribute towards the bill that we introduced to get to the place where we can legalize, strictly regulate and restrict access to achieve the objectives that I've reiterated many times, keeping it out of the hands of kids and the proceeds out of the hands of criminals. Until that time, until this piece of legislation receives royal assent, the law is the law, and we respect local law enforcement officers to do their jobs.
Yes, Minister, but I mean, you just said in your statement that the unequal application of the law is the nature of our federation. Surely that is a reason enough for the federal government in the interim to take the appropriate stance to make sure there is an equal application of the law across this country. So again, why haven't you stepped in as an interim measure to do that? Surely it begs the question.
Well, I appreciate your great interest in this and wanting to achieve the objectives that you've very clearly articulated. I would look to you and to all members of this committee and all parliamentarians to move this legislation as quickly as possible through Parliament so we can get to the place where we achieve the objectives that and the purpose that's articulated.
And just as I think my time is getting close here, now, the Prime Minister, I think you alluded to, he's mentioned previously that pardons for criminal records, is something that might be on the table for marijuana conviction. He has stated that there have been many situations over history when laws come in that overturn previous convictions, and there will be a process for that we will set up in a responsible way. Can you outline to this committee exactly what kind of discussions you've had with the Prime Minister and your colleague, the Minister of Public Safety, in how some sort of a regime for pardons may come about for those who have previous convictions for possession of small amounts of cannabis?
Well, the Minister of Public Safety, the Minister of Health, and myself are entirely focused on ensuring that we move Bill C-45 forward, doing everything we can to work with our counterparts in the provinces and territories to assist them in developing whatever regime they deem appropriate. That has been our focus. There may be a time once we move this legislation forward that we change our focus, but for right now, this is the focus, and this is the entirety of the conversations with respect to cannabis that we've been having.
Okay. Thank you very much. Mr. Biddle.
Thank you so much, Mr. Chair. Minister, thank you so much for joining us. I know a lot of Canadians would be terrified to enter a room with this many lawyers, but I thank you for being here. I'd like to speak to the creation of 28 new positions in Superior Courts, increase of $55 million over 5 years and $15.5 million ongoing. My understanding is that this is addressing delays and responding to the Jordan decision that will require a multi-pronged approach, including collaboration with provincial and territorial leaders. Can you discuss whether this funding is part of a broader strategy to address those delays?
To the yes. We, in addition to the revamping of the judicial appointments process, I have and my officials have been speaking with many different jurisdictions around the need to have additional judicial spaces. And I was, as you articulated, very pleased to see in the budget that we received the dollars for 28 new judicial spaces. In terms of the 28, 12 will and have been allocated to Alberta, one to the Yukon Territory, and I am continuing, as are my officials, to work with other jurisdictions to understand their business case and need for additional judicial spaces, and we will be continuing to do this work to allocate the remaining spots. But broadly speaking, in terms of your question with respect to the Jordan decision from the Supreme Court of Canada, this is definitely a concern of mine, of my counterpart justices, attorney generals across the country. We have had the opportunity as recently as I believe 2 weeks ago to meet collectively to talk specifically about delays and how we can assist each other in our shared responsibility for the administration of justice. Without question, my counterparts talk to me about the need to have judicial appointments in their jurisdictions, but also recognize that we need to address there's no one solution to delays in the criminal justice system, but we collectively identified a number of priorities that we would address that seek to assist in reducing delays around mandatory minimum penalties, around bail, around the administration of justice, around looking at the reclassification of offences, and around preliminary inquiries. I was very pleased with the collaborative approach that we were able to achieve at that meeting, and look forward to the work that we're going to be bringing forward in the near future and into the fall.
Wonderful. Thank you so much. Another program, funding for the Canadian Judicial Council, an increase of $2.7 million over 5 years and $0.5 million ongoing. Can you please comment on why you think judicial training is important and what challenges you think will be addressed by this funding?
Well, I again was pleased to see these dollars allocated, and I'm further pleased to, since becoming Minister of Justice, to rebuild a substantive relationship with the Canadian Judicial Council, benefit from appearing before them twice now, and recognize that we need to ensure we do everything we can in the justice system to ensure we are providing respect and dignity to the diversity of individuals that come before judges, as well as ensuring that judges receive the necessary training to account for our changing environment, whether that be understanding implicit bias, understanding how to deal most appropriately with victims of sexual assault. So the monies that have been allocated will go towards the Canadian Judicial Council doing the work to provide judges with the necessary training to be familiar with how to recognize implicit bias, how to assist in dealing appropriately with individuals that are victims of sexual assault in a dignified way.
So we've had recent examples, and I think you touched on it briefly, but if you could expand, there's been recent examples of problematic judicial conduct in Canada. Will this funding help prevent future instances of such conduct, and if so, how?
Well, I believe the intention of all training that is provided to judges, and certainly in private members' bill that's been put forward to provide training to members of the legal profession who perhaps have the intention of becoming judges, to assist in having that backdrop and recognition that we're a country that has great diversity, and that sometimes individuals, marginalized communities, can require certain approaches or sensitivities for the judge that they are appearing before. So I think it's always the objective in terms of training to provide the necessary tools to judges or to increase their ability to be able to address individuals that come before them and hopefully for all of us, I guess, understand the different realities and circumstances that people are faced with.
Thank you, Minister.
Thank you very much. So now we're going to start our second round of questioning. So just for the committee's recollection, because we usually do it more informally, in the second round it goes Liberal, Conservative, NDP. Okay, so we're going to start with Mr. Fraser.
Thank you very much, Mr. Chair. Thank you, Minister, for being with us today, and for everyone else attending. Thank you very much for taking the time to come in and offer comments and answering our questions. I just want to pick up on Mr. Biddle's questioning regarding judicial training. And I know that funding to combat gender-based violence is something that our government sees as important, and also ensuring that judges receive adequate training and education on matters relating to gender-based violence, including sexual assault. I just want to ask, Minister, is this type of training going to be offered both to Superior Court judges and also provincial court judges? And how are you working with the provinces to ensure that that type of education and training is taking place?
Well, thank you for the question, and it gives me opportunity to reiterate some of the efforts that we've been making in terms of addressing gender-based violence in the work that we do, in addition to the $2.7 million that was talked about in terms of providing training for or towards the Canadian Judicial Council to provide training. We've also provided dollars to the National Judicial Institute to assist in providing the same type of training in terms of sexual assault and gender-based violence to not only Superior Court justices, but provincial court justices, and that's money through the Justice Canada. We, again, further are working, I will continue to work with the Minister of Status of Women in the incredibly important work that she's doing around developing a gender-based violence strategy. And through the victims funds, the Department of Justice has, as I indicated, allocated millions of dollars to support local programs. And we have had the opportunity to have information exchange among many professionals that work in the area of gender-based violence and sexual assault, and have benefited from their experiences. And further, as I said, in terms of the criminal justice review, we'll be looking at how we can further refine criminal code provisions around sexual assault and clarifying provisions around consent.
Thank you, Minister. I believe you had mentioned that $100,000 was the amount that had been set aside under the gender-based violence type of education program for judges. That seems like a rather small portion to the overall justice budget. I'm just wondering if I understood that correctly, and if you could elaborate on what that $100,000 represents.
Yeah, the deputy might want to add a bit here. The $100,000 is for training, as I said, for Superior Court and Provincial Court judges, in addition to the $2.7 that was identified in the budget. And I do want to say, with respect to our esteemed judiciary across the country, I have the utmost respect for the work that they do and the serious consideration and advancement of training and ensuring that they have the necessary tools in place. But Deputy, did you want to make
perhaps just 2 points? First, the National Judicial Institute, which is a creature of the judiciary in the sense that government shouldn't be telling judges what training or delivering the training directly. So we should be proud that we've got something like the National Judicial Institute. I think it's recognized as a jewel of the crown in terms of support for our judiciary, both in the Superior Court and at the federal level, and to the extent they can in supporting provincial judges. But it's a big country, and judges are very busy hearing cases. So part of what the 100,000 we hope will allow the NJI to do is to expand their already existing offerings and to make them available online as well. So the NJI already runs in-person training on social context, specifically on sexual assault and on managing sexual assault trials and those sorts of things. What we're trying to help them to do as well is to expand those offerings to make them more available online. So $100,000 doesn't sound like a lot, but in addition to the existing investments that have been made in judicial training and the new money in the budget, we think it will allow them to provide robust and comprehensive training both to the Superior Court judges and to the Provincial Court.
Very good. I have time for a quick
Kevin,
question.
yeah.
With regard, switching gears a little bit, the judicial advisory committees and the new process for appointing committees across the country for judicial appointments, I'm wondering where we're at with those committees and how many of them have been put together and how many are left to be done and what the timeline looks like on getting those all going.
Thank you for the question. And in terms of the judicial advisory committees, the vast majority of them are constituted. I know the New Brunswick JAC hasn't been, and my apologies, I don't have the exact numbers. I can provide them to this committee, but most of them have been constituted. They have been incredible in terms of the commitment to reviewing judicial applications on an expedited basis, and when they review and highly recommend or recommend a particular individual, it comes across my desk very quickly thereafter, and I make a decision with respect to the individual and make decisions with respect to the urgent needs in the jurisdictions. I've been very pleased over the last month plus on an ongoing weekly basis to make judicial appointments, and that is going to continue. Having appointed now 55 judges, 22 deputy judges, more will be coming in the very near future.
Hey, thank you very much.
Thank you.
Mr. Cooper?
Thank you, Madam Minister. The first issue that I do want to raise is with respect to Bill C-39, which you made reference to. That's the bill, of course, to remove constitutionally inoperative sections of the Criminal Code. I want to thank you for your leadership in introducing that legislation. I know that our chair led this issue following the conviction of 2 counts of second-degree murder in the case of Travis Fader being vacated after the judge applied a constitutionally inoperative section. And it's an issue that I raised, given the close connection that case has to the community that I represent of St. Albert. That bill was introduced on March 8th. It's now been 2 months, and nothing has happened. How many more months will it be before Bill C-39 is debated in Parliament?
Well, I thank you for the question. And again, you acknowledged the chair, but I would acknowledge the entire committee that sent me a letter, and I very much appreciate it and the urgency of advancing cleanup of the criminal code. As I stated both in the House and outside, this is the first phase, Bill C-39, of the cleanup. I am hopeful that this piece of legislation will move as quickly as possible. I certainly don't know how quickly that will be, but I think it's very important, and when it does come back, I'm hopeful that all members will support it moving quickly.
Okay, now turning to another issue, one that had been raised by Mr. Fraser, that being judicial advisory committees. You mentioned that the vast majority of judicial advisory committees have been filled. However, as of today, 7 out of 17 judicial advisory committees have not been filled. That includes it for the provinces of Manitoba, Saskatchewan, New Brunswick, the Southwestern Ontario, Northwest Territories, Nunavut, and the Tax Court of Canada. How can you say that the vast majority of judicial advisory committees have been filled?
Thank you for raising the question again. As I said, Mr. Fraser, I'm happy to provide the list of the outstanding judicial advisory committees. The vast majority of judicial advisory committees in jurisdictions that have urgent need, not to say that they're not all urgent, I'm committed to filling all vacancies, are working diligently to bring forward names. But I'm, again, pleased to provide the honourable member with a list of outstanding ones. But we will be working to have those remaining JACs in place soon.
Minister, I guess I already provided the list. And in addition to that, Nova Scotia, Yukon, and Quebec East were vacant as recently as a month ago. Now, you reconstituted judicial advisory committees in October. How do you justify the fact that it's been now 6 months, 7 months, and we have 7 out of 17 of these JACs empty, and as recently a month ago, 10 out of 17?
Well, I am working diligently to ensure that our new judicial appointments process moves forward. I'm pleased to have reconstituted the judicial advisory committees and am working with partners to ensure that we identify and appoint names to all of the judicial advisory committees, committees that certainly reflect a diversity among Canadians. Pleased that the judicial advisory committees will receive training, implicit bias training, but we redid the appointments process and the judicial advisory committee process to ensure that we do as much as we can to end up in a place where my judicial appointments reflect the diversity of the country, and I'm incredibly pleased on the inroads that we've made in that regard. In some jurisdictions, appointing over 65% women, diversity including Indigenous peoples, LGBTQ people or individuals. So I'm pleased with the way that the appointments process is unfolding and the substantive caliber of the individuals that have been recommended or highly recommended to me.
Well, I tell you who's not pleased, and that is the families of victims who have seen serious criminal cases, including first-degree murder, child abuse, sexual assault cases being thrown out. Thousands of cases are at risk. The Jordan decision is not new. It was issued last summer. The response that you took to that decision was to dismantle the judicial advisory committees. We now have 62 judicial vacancies. You said you have appointed 55 judges. There are more judicial vacancies than you have managed to appoint in the last 18 months. Months have gone by over the last 18 months in which you have failed to appoint a single judge. The number of judicial vacancies is at a near historic level. It's just unheard of to have 62 judicial vacancies, and it's not 62 this month. This has been the case for a long time. What is it going to take before you fulfill your duty as Minister of Justice to fill judicial vacancies in a timely manner? How many more cases are going to be thrown out before that happens?
Well, I am pleased to be fulfilling my role as Minister in appointing substantive candidates for judicial appointments to our superior courts. You indicated that the Jordan decision is not new. I will say that delays are not new. They have been around for a long time. There is no one answer to solving delays in the criminal justice system. This is why I've been working very collaboratively with my partners in the provinces and territories who have responsibility for the administration of justice and 99% of the criminal cases in provincial courts. This is why we are taking a substantive collaborative approach to do as the Supreme Court of Canada directed us to do, is is to have a culture shift in the justice system, and a culture shift requires rethinking of all the actors within it. We are going to collectively look at mandatory minimum penalties, which lead to delays. We're going to be looking at preliminary inquiries, bail, the administration of justice, to ensure that we do everything we can to reduce the delays. Simply thinking that by appointing judges, which I am committed to doing on an expedited basis, is going to solve those delays in the criminal justice system is certainly not the case. For 10 years, the previous government did not address these delays, which have been around for a lot longer than that.
Okay, thank you very much. Mr. McKinnon.
Thank you, Chair. Thank you, Minister, and thank you, officials, for joining us today. Some of these faces are becoming very familiar. I'm interested in the Indigenous Justice Program. I wonder, Minister, if you could describe this more fully and why you believe it's important to make funding permanent.
Well, thank you for the question, and I'm really pleased that the money for the Indigenous Justice Program has been made permanent. And we can look at many examples across the country where community approaches to different ways that we can address individuals that find themselves in the criminal justice system that are culturally appropriate is something that I applaud and want to continue to pursue. The over-representation of individuals, marginalized individuals, Indigenous peoples in the criminal justice system needs to be addressed, and needs to be addressed through innovative practices, through culturally appropriate practices, through certainly prevention in terms of addressing the ongoing reality of the colonial legacy, but also in terms of restorative justice measures, which is where the Indigenous Justice Program is so great in assisting us in finding what other measures we can support to do as much as we can to create off-ramps so individuals, Indigenous peoples that find themselves in the justice system can take advantage of those off-ramps, of those restorative justice measures. And I've been pleased, along with my officials, to have many roundtables across the country where we learn of substantive examples that communities are undertaking in this regard. And it's not, I will say, just with respect to Indigenous peoples, but it's looking at different approaches to rehabilitation, to different off-ramps to assist in what I believe is a fundamental obligation, is to look at rehabilitation in the criminal justice system for individuals that may be there, and there's a substantive amount of individuals that are there due to marginalization, poverty, individuals dealing with mental illness and addictions. We need to find ways to ensure that we are doing everything we can as a government and as a society to assist those individuals and give them the help that they need in terms of addressing those addictions, as an example.
Thank you, Minister. I'm going to move on. So I was fortunate enough to have a chat with the Deputy Premier of Nunavut yesterday. I note that through the Access to Justice Service Agreements, the Department of Justice supports the delivery of access to justice services in northern communities. And this includes criminal and civil legal aid, Indigenous court work services, and public and legal education and information. So are these funds specifically for the territories, or are northern communities in the provinces also included? And are the eligibility criteria for legal aid different in northern communities?
Perhaps, Mr. Chair, I can take that question. Thank you for the question. Recognizing the differences in the territories in terms of size, scope, scale, we've combined a series of programs, and as you said, we've been, for many years now, combining a variety of programs through access to justice agreements. As given the jurisdiction and responsibility that provinces and territories have for legal aid, they each establish their own eligibility and administration requirements. But we have found, in collaboration with the territories, that the access to justice agreements offer them a degree of flexibility, given that they have a lot of land and few people, if I can put it that way. That their administration of justice is different. There are similarities across, for example, say if you go from northern Quebec to northern Ontario across the northern parts of the territories, and certainly provinces collaborate through that, but we provide funding for legal aid and other programs to the provinces. I would say, though, that there is, if you like, a northern collaboration south of 60, given the similarities there. But the truth is that the provinces have a program administration capacity that's different than what the territories currently possess. And so we transfer program by program to the provinces.
Thank you. Mr. Chair, I'd like to share the rest of my time with Ms. Khalid.
Sure, you have about a minute left.
Thank you. And thank you, Chair, and thank you, Minister, and everybody for coming before us today. Minister, I was reading in the paper today that a certain Ms. M, whose testimony had proved vital to the expulsion of a senator from our Senate, felt that she could not access the Ottawa Police because she feared for her identity being made public and didn't feel safe to enter into that system. We've really undertaken an in-depth study as to access to justice, and I personally have found that women tend to not have as much access as others. For example, the women tend to need family court a lot more than, for example, males do. We heard testimony with respect to unified family courts. I'm wondering if you can expand on what our government is doing with respect to perhaps investing in this type of process to assist with more equality with respect to access to justice for women.
Well, thank you for the question. And in terms of women and women that have faced gender-based violence or sexual assault, we've talked a lot about what we've been doing here at this committee and beyond. But in terms of, and we'll continue with those efforts to ensure that we provide a safe space for individuals to feel more free to come forward and that they're provided with the necessary protections. In terms of unified family courts, this, as you know, was in my mandate letter. It is something, our unified family courts are showing substantive benefits and progress in terms of providing increased access to justice in jurisdictions. And I've had the benefit of speaking with a number of my counterparts in the provinces in this regard. I have had the opportunity to ask my counterparts whether they have an interest in either increasing their unified family courts or becoming more involved in an initiative in that regard. That work is ongoing. We continue, and my officials, more importantly, continue to have discussions within the provinces to see how big the interest is, and I'm hopeful that we can move forward with respect to unified family courts in the next year. Thank you.
Thank you so much. Mr. Falk.
Thank you, Mr. Chairman, and thank you to the Minister for coming to the committee. I was recently watching a panel discussion where you and the Minister of Health were discussing the marijuana legislation, the proposed marijuana legislation. And I forget even who the host was, but of particular interest to me was a comment that you made that you had not ever been a cannabis user, nor did you expect to be after this legislation was passed. And so my first question, and I'll ask them both, but is why is it not a good thing for you, but it's okay for others and even for the youth of our society to have access to cannabis as a recreational drug? And so that's my first question, and I commend you for your position, your personal position. But secondly, when I look at the legislation that you say you're very proud of that your government has presented so far in the last year and a half, and I look at C-14, which is the medical assistance in dying legislation, which now allows Canadians to legally have their lives terminated with the assistance of a physician. Bill C-16, which addresses what I think is an imaginary gap in both our Canadian Human Rights Act and our Criminal Code. Bill C-32, which repeals Section 159 of the Criminal Code, which addresses anal sex. And Bill C-37, which repeals the Respect for Community Acts, which will now make it easier for safe injection sites to be located in different communities right across Canada. And of course, the most recent one, Bill C-45, the legalization of marijuana. And my question on all those issues is I think quite simple. It seems to me that these pieces of legislation seem to have a particular theme to them, and I'm wondering what is it that motivates your government to, in my opinion, be so bent on recklessly determined to destroy our social and moral fabric.
Well, I completely disagree with your last statement. Our government is committed to ensuring that we uphold the Canadian Charter of Rights and Freedoms and ensure that everybody, one, has the freedom to be themselves, ensure that every individual is accorded the same respect and dignity in a country as great as Canada. As Minister of Justice and the Attorney General of Canada, I will and not ever apologize for putting legislation forward that provides the means for individuals who qualify to access medical assistance in dying. I will not apologize for ensuring I protect the rights of those who have a different gender identity or expression. Bill 159 of the Criminal Code has been deemed unconstitutional, and we are going to move that legislation forward. We are making decisions as a government that ensures we uphold what makes this country great, which is its diversity. We benefit from having a Charter of Rights and Freedoms, and it is my most important job that we ensure that we uphold those rights. If I didn't do that, I wouldn't be doing my job. And I will not apologize for those pieces of legislation, but I will stand up and I will shout from the rooftops as to the substantive public policy that stands behind each of those legislation and then those bills. I would be happy to have a conversation with you, sir, about the public policy reasons behind all of those pieces of legislation. And as to whether or not I've smoked cannabis, it is completely irrelevant whether or not I have smoked cannabis. What is relevant is the public policy reason why we put forward Bill C-45, and that is to ensure when we legalize, strictly regulate, and restrict access to marijuana, that we do better than the status quo right now and ensure that we keep it out of the hands of kids and the proceeds out of the hands of criminals. So if you want to challenge me on the public policy reasons behind the legislation, I'm happy to engage in that discussion.
Thank you very much. So Mr. Nicholson is asked to have one short question at the end of this time, and so Mr. Falk is sharing with Mr. Nicholson.
Yeah,
you have a very short time.
On the subject of judicial delays, one of the suggestions that's come, I know, from the Attorney General of Ontario and some others is to have a look at the area of preliminary hearings. In your opinion, would you think this might help expedite the criminal law process here, and would you consider it?
Well, we agree that this is one of the areas as justice ministers across the country that we would look at. I know that preliminary inquiries is not without its controversy in terms of different approaches. I've been approached by, as you say, the Attorney General of Ontario and Manitoba to consider this, and that is the work that we as justice ministers are going to undertake over the summer and come back in the fall and see what we can do, not only in the area of potentially preliminary inquiries or maybe other modes of disclosure that we can address, but also looking at bail, the administration of justice, and sooner than that, looking at mandatory minimums. All of these things contribute to delays in the criminal justice system.
Thank you so much. Last question, Mr. McGregor.
Thank you, Mr. Chair. Thank you again, Minister. Pleased to have this follow-up. Now, your government has now been in power for nearly 19 months. We had the Jordan decision rendered in the summer of last year. And I agree with you that it's not just appointing judges that will fix the delays in our justice system. There are many different areas. I think the Canadian Bar Association, came out with a top 10 list. I think number one was appointing enough judges. I think our criticisms are valid in that it has taken a while to get to this process, and we would urge you to do a bit faster. I mean, 19 months is a fairly long time. But they've also talked about adequately resourcing legal aid, and as you know, that this committee is currently conducting a study on legal aid, and I certainly hope you will listen to our recommendations. But also, one of the biggest ones was resourcing the system. And it's on that particular point I want to concentrate on the resources because, of course, courts need a lot of administrative staff. They need the places in which to sit. There are a lot of people involved in making sure that a well-functioning court system is operational. And I think you would agree with me that Canadians need to have faith in our justice system. It's one of the main pillars of our democracy. And I know that you're concerned, as we are, that when serious criminal charges are being stayed or withdrawn, Canadians start to lose faith in that. It's a very real issue. So in light of the resource part, making sure that resources, I want to know from you, from your department, in your opinion, how many resources in our courts and in our police are currently tied up with the crime of cannabis possession? And as a follow-up, does the Department of Justice have any figures on the number of people who have been charged and arrested for minor cannabis possession since your government came to power?
Well, thank you for the last two questions. I don't have those specific answers. I know that once I leave here that public prosecutions will be here. If we don't have the specific answers, we're very happy to do what we can to follow up and provide you with those answers in terms of the resources and in terms of charges. But again, so I'm happy to do that as a short answer to your question. But in terms of resources generally, this is a subject that, on legal aid, I'm very happy to have made additional investments into legal aid.
Cannabis, right? If Jordan is a big problem for our justice system, like that decision is an issue, like how many of our court resources are being tied up with something that's going to be legalized by your government next year? I mean, wouldn't that be a good fix in the meantime, Minister? That's what I'm trying to get to.
Certainly the Public Prosecution Service would have more, but if you look at the top 10 offences as reported by the Canadian Centre for Justice Statistics, impaired driving will be number one or number two. Offences, broadly speaking, against the administration of justice will be probably 3 out of the top 5 in all jurisdictions. We will be happy to provide you with further information about simple cannabis possession, but if you want to look at volume, impaired driving is, as I say, number one or number two, and out of the top 10, easily 3 of the top 10 or 3 of the top 5 would be, broadly speaking, offences against the administration of justice. If you look broadly speaking at the elements that are driving delay, there are a variety of those contributing factors. Public Prosecution Service could at least, I'm sure, provide you further information on their prosecution efforts. You'd have to ask RCMP and other police in respect to police resources.
Thank you.
I know the Minister and Mr. Pentney have another engagement, so I'd like to thank you, Minister, for coming before our committee and answering our questions so eloquently, and Mr. Pentney as well.
It'll be fine.
And it is much appreciated. Let me ask colleagues, would you have questions for the services beyond the questions that have already been asked to the Minister? So I think we can. Mr. Biddle had a short motion.
Okay. The Miscellaneous Statute Law Amendment Act be referred to the committee on May 18th, 2017. Thank you.
Thank you very much. Everybody good with that? And then we have the motions on the main estimates. So our colleagues, can we do that as well before we break? Everybody good with that? So shall vote number 1 under Administrative Tribunal Support Service of Canada carry? Everybody okay with carrying it? Vote number 1 under Canada Human Rights Commission. Everybody good? Vote number 1 under the Courts Administration Service. Vote number 1 under Department of Justice. Vote number 5 under Department of Justice. Very good. Vote number 1 under the Office of the Commissioner for Federal Judicial Affairs. Vote number 5 under the Office of Commissioner for Federal Judicial Affairs. Vote number 1 under the Office of the Director of Public Prosecutions. Vote number 1 under the Registrar of the Supreme Court of Canada. And may I report all of these votes back to the House? On division. Okay? Okay, carried on division. And reported back to the House on division. Thank you very much, colleagues. I wish everybody a very, very good rest of your Thursday. Meeting adjourned.
You